So I did a video on this already in the past, but I just want to sort of keep you up to date as to what's going on here. They had several motions to the court, and Juul Labs Incorporated attempted to dismiss this entire complaint. It was the class action suit in regard to adults as well as teenagers or those under the age of 18 getting highly addicted to the nicotine salts. Juul Labs moved for dismissal of the entire complaint, and they had the judge had ruled that some claims can remain and possibly a leave to amendment, meaning that the claim can be amended and then submitted back to the court. Certain areas can be corrected in whatever motion. And then other areas, Juul Labs won. So certain claims were dismissed, and other claims were denied, or I should say, denied and granted. So I just I said, I don't know, last year sometime that I'll keep up on this. So I'm going to share it with you. I won't make it too long. Hopefully, I'm going to just mainly speak to what is denied and what is granted. I don't have to go through the whole thing. It's pretty long. It's about a 70-page ruling, so I don't want to go through all of it. So that's I mean, like, there's three lawsuits that are pending. One is the Nicopure Labs is still pending on appeal. It's been a while, and it's been still pending there, and it can stay there for a while too. It's almost a year now. It's pending still with the three-court judge, appeals court. And this particular case, also, I wanted to keep up on Juul Labs Incorporated, and the other one was, I can't remember. Oh, and the health groups that are suing the FDA. So these are the three main lawsuits that I tend to try to keep up on. There are several other lawsuits out there that are against the Food and Drug Administration and things of that nature, but whatever as far as they are concerned. And I have them all up on this channel, but they're still all pending, by the way. Every single lawsuit is pending. Even the Lost Art Liquids that started back in 2016 is still pending in court. Anyway, so this is out of a United States District Court, but it's in the Northern District of California, because it was filed in California, of course. And this is called Bradley, Colgate, and the following, that is the plaintiffs versus Juul Labs Incorporated defendant. It's case number 18-CV-02499-WHO. When you see any kind of lettering, that's the initials of the judge. You see CV, that'll be for civil court. And this came down. I should have kept up on it even more, but I just I was curious. About 2 days ago, I said, well, let me take a look. Apparently, this ruling came down quite a while ago, October 30th, 2018, but still. Something that Juul Labs Incorporated definitely don't want the public to know about. I mean, they're so busy suing many other companies for counterfeit Juuls that they also got sued. And some of the claims against Juul Labs Incorporated is sticking. In other words, they will go to trial on those. In other words, let me explain that so you understand. The claims that were granted to the plaintiffs that are suing Juul Labs Incorporated, those particular claims will go to trial. So they will go to trial, and probably it'll be settled out with Juul. Juul Labs will settle the case so it doesn't go to trial. That's usually what happens, like 90% of the time. In these civil cases, they usually are settled before either they go before a judge to have a ruling on it, or they go before a jury to have a ruling on it. Even goes for criminal cases as well. They'll take a plea deal and admit guilt, on certain charges, and then it'll be wrapped up, and the person will get either probation or a lighter sentence or whatever. Normally, even in criminal, in civil matters, even in bankruptcy, it depends on the trustee, but even on the bankruptcy, they'll settle on certain issues if need be. Even maritime law, even like a court martial, for instance, if you're in the armed services, instead of going to the full jury, it will settle before it hits that point. And this probably is going to happen with Juul Labs Incorporated as well. So here you see all the plaintiffs, and then you have a minor. They call him MH. He's a minor. He's under the age of 18. And then you have the Juul Labs Incorporated. And these are all the lawyers that they employed. A lot of law firms. He's got Juul Labs hired 1, 2, 3, 4, 5 law firms. 5 law firms. That's the kind of money that Juul Labs Incorporated has. So it says, order partially granting motion to dismiss and denying motion to strike. And when they say strike, that is strike certain areas of certain claims. This is references docket numbers 40 and 41, and that's the judge, William H. Ark, district judge. Now, I'm just going to read a little bit so you understand what's going on here, and then we're just going to go right to they're like little short paragraphs of what's denied and what's granted so you can understand. So it says, plaintiffs are adults and minors from 7 states bring class claims against defendant Juul Labs Incorporated, a market leader in the burgeoning electronic cigarette industry, for various state law violations related to Juul's advertising and labeling of its electronic cigarettes. Juul argues that the Tobacco Control Act, 21 United States Code 387, and the following TCA preempts plaintiffs' claims. It is partially correct concerning its product labeling because the TCA is very detailed about what must appear on the label. And so I'll explain that real quick. On the label, you have the Food and Drug Administration / the Center for Tobacco Products can only regulate 30% of that particular label, whatever label it may be. It could be on an e-liquid bottle. It can be on a hardware. It doesn't matter. It can even be software. Like if somehow or another, I've yet to ever see it. But let's say for the Lost Vape Therion, normally you get the software online. But let's say they decide to put it on a DVD and send it to you along with the mod. That DVD would be regulated. But even the online software is also regulated. Okay, so you understand this stuff. And all of this stuff must have that 30% requirement on there. And those requirements are very, very, like he says, very detailed. And that is, you must say nicotine is highly addictive. It must be in 12-point font size. It's very detailed. It doesn't say exactly, the requirement does not say, you must say that let's say we'll do e-liquid. It doesn't, the FDA requirements does not say, well, you have to explain exactly what is inside the e-liquid, the formula itself. That is, what kind of flavors, what kind of VG, what kind of PG, what kind of nicotine. It doesn't even say if you have to put down, necessarily, you have to put down, 3% nicotine. Normally, that falls under the FCC, unless the Federal Trade Commission, that is deceiving the public. Okay, that's a whole other ball game. With the FDA, they've yet to write that into their rules, because when the Family Smoking Prevention Tobacco Control Act of 2009 came down, at that time they didn't have e-liquids in 2009 in regards to regulating e-liquids. I mean, they dealt with combustible cigarettes, smokeless tobacco, cigarillos, and it never says on a pack like on a pack of cigarettes. It doesn't say you're getting 0.9% nicotine. It doesn't say that. That didn't come until much later. And in the FDA final rule that went into the Federal Register on May 10, 2016, and nothing in there says that one of the requirements is that you have to put down what kind of percentage of nicotine, what the flavors are, things of that nature. All it says basically is that it's a highly addictive product, nicotine is, and it must be 12-point font size and must be at least 30% covering of the packaging or the bottle, or it could be something that's attached to the bottle by a string, but it has to be on a little card or whatever have you. Now, there's an area in here that Juul Labs Incorporated lost on because it's misleading, not so much FDA, but it's misleading as far as saying that they have 5% or 50 milligrams of nicotine salt in their product, when in fact they really have 6.2. So that's 60%, right? No, excuse me, that's 6.2 milligrams. All right, sorry about that. I am terrible at math, and if anyone knows me, I am seriously bad at math. So it's 6.2%. So that would be about a little over 60 milligrams of nicotine salt that are actually in these pods, even though they say it's only 50 milligrams. It's really over 60 milligrams, but we'll get to that in a moment. So I just want to explain that. So certain areas, Juul Labs had one on, and other areas they have not. So I just want to explain what this thing is going on here with the labeling situation here. It says, but claims that Juul misrepresents the amount of nicotine in its products are not preempted. Juul also moves to dismiss plaintiff's first amended complaint because it fails to meet Federal Rule of Civil Procedure 9b's heightened pleading requirements to state a claim and to identify applicable state laws. As discussed below, I grant in part and deny in part Juul's motion to dismiss with a leave to amend. So Juul can amend their motion to dismiss, and then they come back and they look at it again. The judge will look at it again, and then the judge will decide if it should be dismissed or not. Then it says Juul's motion to strike plaintiff's nationwide class allegations pursuant to Federal Rules of Civil Procedure 12F, 23C1A, and 23D1D is not ripe and is denied. Now that's flat out. So regardless of how they amend that motion to dismiss, the class action itself will continue on in one form or another. And that's why they usually settle out. They usually will settle things. And then you could read that. Take a vape. You could read that a little bit. All right. You read the Juul products, basically, so you understand. All right. But yeah, understand a little bit. But anyway, so let's go to Juul's advertising. This is one of the claims that they spoke of. And we'll just go really down to where the judge rules at. And he explains it. I mean, he explains it very well. Okay, so this is the legal standard motion to dismiss, okay? And he gets into the particulars of cases, and then he makes his ruling. Okay, so it was a motion to strike by Juul. Okay. I really just want to get to the gist of this. So you know, because my videos can last 2 hours, and I could do a 2-hour video of this, but just want to sort of get to the point of it. So there's 11 causes of action. There's false advertising, a violation of Consumers Legal Remedies Act. It's a civil California Civil Code. Fraud, unfair, unlawful, and deceptive trade practices, business and professions code. These are mainly state laws. Unjust enrichment, strict liability, failure to warn, strict product liability, design defect, strict liability, manufacturing defect, breach of implied warranty of merchantability, breach of express warranty, and negligent misrepresentation. So that's the causes of actions. Okay, so it says Juul moves to dismiss for 3 reasons. First, they argue that plaintiffs' claims are preempted by the Federal Food, Drug, and Cosmetic Act, as amended by the TCA, or the Family Smoking Prevention Tobacco Control Act, which provides the Food and Drug Administration with exclusive authority to promulgate regulations on ENDS labeling, that's electronic nicotine delivery system. Second, they contend plaintiffs' fraud claim fails to satisfy that particular rule. You see, heightened pleading requirements. Third, they assert that plaintiffs failed to allege sufficient facts to plausibly satisfy the elements of any of their claims. So, and then the judge will rule. We'll get down to his rulings. Just want to get to his ruling. Okay, so here's one of his rulings. So this is what the judge determined. I find that Congress has intended to expressly preempt labeling requirements on ENDS packaging as shown by the preemption clause in the TCA and the specificity of the FDA rule on labeling. Plaintiffs believe that Juul should be required to warn consumers of the pharmacokinetics, that is a greater potency, its benzoic acid and nicotine salt formulation delivers. If plaintiffs' claims were allowed to go forward in this respect, it would constitute a usurpation of the power vested in the FDA by Congress to regulate the content of the warnings on covered tobacco products. Plaintiffs' labeling claims are preempted to the extent that they are related to Juul's failure to warn consumers that, and you see that word, of their formulation, even at a similar percentage of nicotine, is more potent than it would be in a traditional cigarette due to its chemical makeup. Juul may only be required to comply with the labeling requirements as articulated by, to the extent that plaintiffs' claims are based on the product label failing to disclose the greater potency and addictiveness of Juul's benzoic acid and nicotine salt formulation. Juul's motion to dismiss is granted. These claims are necessarily dismissed with prejudice. And when they say prejudice, that means on this particular claim, no court can ever hear these claims again. When they say with prejudice, that means it can never be revisited by any court. So this is mainly has to do with plaintiffs' labeling claims are preempted because Juul failed to warn consumers of their formulation. They don't necessarily have to do that. The FDA, the way it's written into the regulations, it doesn't say, the Food and Drug Administration doesn't require manufacturers to say exactly what is in their formulation and put it on their label. It does, in other words, what the claimants or the plaintiffs are saying here is that we should have known. I mean, Juul had a legal responsibility to notify the public through their labeling that it contained benzoic acid. No, as far as the Food and Drug Administration, they're not required to put down benzoic acid on their label. Maybe someday they'll have that, but right now that's not the way it reads, as well as it comes out of the Family Smoking Prevention Tobacco Control Act, as well as the Federal Food Drug and Cosmetic Act. Okay, nothing in there says you have to put down what types of flavors or what type of VG or PG or any of that, or even what type of nicotine you're using inside of the formulation or formula itself. You only have to put down mainly that nicotine is highly addictive. That's mainly all these manufacturers have to do, outside of 12 point font size and things of that nature. And it has to be at least 30% of the label. I mean, that's pretty much all it says. Okay. So apparently, what the judge is basically saying is that a plaintiff, or you and I, or no one, until Congress goes in there and rewrites it, or the FDA, through a final rule of their own, finally comes out with a different way of describing what you ought to put on your labeling, no one can tell a manufacturer, and it doesn't just go for Juul, it goes for any liquid manufacturer, let alone hardware manufacturer. In other words, a perfect example, Joytech or Tesla or, I don't know, Eton. They don't have to put on the label how their board is made. You know, they don't have to describe how they made the product. That's not required under the TCA, as well as the the federal FDC and federal FD&C Act. It's not required. You understand? So they don't have to put down necessarily that benzoic acid is the formula that's in the Juul product. So hopefully we understand that. So, and that's across the board. And that was determined by the court. And that's certainly understandable. But the judge can only go by how Congress has framed that Family Smoking Prevention Tobacco Control Act, as well as the FDA final rule, as well as whatever regulations that the FDA has come up with and approved by the Office of Management and Budget, and that is in the form of a final rule. So that's gone. Now, the next thing. Okay, so it says plaintiffs allege that the actual percentage of nicotine contained in Juul pods is 6.2%. This difference would constitute over 20% more nicotine than Juul claims its products deliver. Okay, so just hold that in mind. So, this is the judge's ruling. Juul argues that plaintiffs misread Juul's 895 patent and the Panko study. At the motion to dismiss stage, I must accept all the factual allegations as true and draw all reasonable inferences in favor of the plaintiffs. So, in other words, according to these rules and case laws, the judge or the court itself must be given the benefit of the doubt to the plaintiffs and be reasonable in regards to that. So this is his ruling. For the purposes of this motion, I accept plaintiff's factual allegation that Juul's pods contain 6.2% nicotine rather than 5% Juul represents on the packaging. To the extent that plaintiff's labeling claims are based on Juul's alleged mislabeling of the strength of nicotine in their pods, Juul's motion to dismiss is denied. So it's pretty much this particular claim that went into the favor of the plaintiffs against Juul that keeps pretty much this entire lawsuit above board. Not above board, but it keeps it, it survives. It survives. It's not dismissed completely. this is really the only thing that really is. I mean, there's one other thing, and I'll show you in a moment. But this is really the only thing that that survived that motion to dismiss. So on this particular point, it can continue on. Now, you have to dismiss my. I still have a cold I'm recovering from. It creeps up on you out of the blue, and it's nasty. Anyway, so what Juul will have to do is, through motions before the court, prove to the court that it's 5% and not 6.2%. Because if not, I don't want to lose this page, which I am going to, but in these particular areas here, and then here, see, it's mainly coming at under state law as well. But like it says, unfair, unlawful, and deceptive trade practices. See, that's deceptive. All right. And the other one is strict liability, failure to warn. It falls under that. Could fall under fraud as well. And that's pretty much it. And possibly negligent misrepresentation. Because in other words, let's say it's 6.2%, right? Instead of 5%. I mean, a person probably is going to be addicted to nicotine salts anyway at 50 milligrams, but at 60.2 milligrams, they're probably even going to be addicted even more. But the point is that Juul has a legal responsibility to inform the public that is the case. Now, it's not necessarily falling under the Family Smoking Prevention Tobacco Control Act, whereas it's falling under the state laws. Understand, like it says, violation of Consumers Legal Remedies Act. It's coming at it comes under California Civil Code. And that's why that particular claim survived. Anyway, let me get down to where it was. Where was I at? Okay, here. So, all right. So that's one thing that Juul will have to either revisit or figure out, prove to the court otherwise. But right now, they're in the hot seat. Even with their 5 law firms that are representing Juul, they apparently lost on that motion to dismiss. Then we'll go on to the next thing. And this is the other thing. So this is retroactivity of the FDA final rule. Says the TCA states that no state or political subdivision of a state may establish or continue in effect with respect to a tobacco product any requirement which is different from or in addition to any requirement relating to tobacco product labeling. To allow plaintiffs to pursue claims on conduct preempted by the TCA and FDA rule, which took place before August 8th, 2016, would continue in effect policies preempted by federal law. I agree with Judge Selner, I guess. Plaintiffs may not pursue their claims for conduct preempted under the TCA, which took place before August 8, 2016. See, Juul products were not regulated by the FDA until after August 8th, 2016. So any claims that are related to anything before August 8th, 2016 is irrelevant and therefore must be denied. And that's exactly what he did to Judge. And then they say, well, claims survive preemption. Okay. So the other one is the exception clause expressly accepts advertisements from preemption in no aspect of plaintiff's claims based on allegedly misleading or fraudulent advertising is preempted by the TCA, including the issue of warning consumers about the potency and addictiveness of Juul's benzoic acid and nicotine salt formulation. Resolving all inferences in favor of the non-moving party, this would apply to any plaintiffs who may have seen an advertisement but failed to closely read the label. Plaintiffs' causes of action based on advertisements or the mislabeling of the amount of nicotine contained in each pod are not preempted by the TCA. It goes on a little bit more. Let me get to the other point because it's sort of wrapped up into something else. A moment here. So it goes on to say, plaintiffs have failed to specifically identify what the advertisements they saw, and as a result, neither I nor Juul can determine precisely what statements were allegedly false, misleading, or unfair. They have also failed to state where, other than on social media, they sold Juul's advertisements. And this is all these advertisements back in 2015, 2016, 2017, mainly 2015. But they can't say where these plaintiffs, mainly the minors, cannot say exactly where they saw these particular advertisements. And because they can't remember or recall exactly where they were at, that particular thing is dismissed. It goes on to say, plaintiffs cite a number of cases to argue that they are not required to state exactly when they saw the advertisements, only that they saw the advertisements during the class period. I agree. Plaintiffs have sufficiently alleged that they saw Juul's advertisements during the class period for the purposes of surviving Juul's motion to dismiss. It's kind of weird. Advertisements during the class period. Anyway, nevertheless, because plaintiffs have not identified which advertisements they saw during the class period or where they saw them outside of social media, I grant Juul's motion to dismiss plaintiffs' false advertising. These claims are dismissed with leave to amend insofar as they relate to claims based on Juul's advertisement. So it's dismissed with leave to amend, meaning that the plaintiffs can go and amend it. Maybe they can recall exactly where they saw these advertisements, pinpoint it, date, time, place, and then resubmit the motion to, or resubmit a motion to the court in order to circumvent that Juul's motion to dismiss that particular claim. Failure to state a claim under state consumer protection statutes. And they cite a whole slew of them. And it says, first, Juul argues that dismissal of plaintiff's claims based on unidentified consumer protection statutes is justified because plaintiffs have failed to identify the subsections of the various states besides California's consumer protection laws they are seeking to invoke. I agree. Motion to dismiss at 1920. When it says 1920, that means the page, meaning at page 1920 of the motion to dismiss. And then the judge says, I agree. Plaintiff's second cause of action only identifies the relevant laws of Massachusetts, and you see the rest. It is not my role to search for unidentified state statutes and the relevant subdivisions. It's true. When you appear before a judge, especially when a judge is deliberating, but mainly when you appear before a judge, you better have your act together. You better have all these statutes. I mean, you would think that the lawyers of these plaintiffs would have all this information to provide to the judge. It's not the judge's responsibility to look over whatever state that may be in favor of whatever the plaintiff's motions may be, or in favor of their motion or a claim for that matter. You have to present your case to the judge, period. Now, the judge is going to look at the law. That's all the judge is going to do. He's not going to go and have a fact-finding mission and try to find some new facts to back up your case. No, judges don't do that. And if they do, it's very rare. And you should be very pleased that the judge did that, because he or she doesn't have the legal responsibility to do so. All the judges have to do, the judge's role, legal responsibility, is to apply the law, period. Why the plaintiff's lawyers failed to do this, no idea. But apparently they did. So it goes on to say, plaintiffs have only identified California's Consumer Legal Remedies Act with specificity. Plaintiffs' claims under the laws of other states are dismissed with leave to amend. So once again, I mean, he's a pretty good judge. He's saying basically, look, submit another motion to the court, explain exactly how all these other states are involved, and be specific and factual, and then amend the motion, and then submit it back to the court. And then the judge will look it over again. It says, should plaintiffs choose to amend their claim, they must identify the state laws they seek to invoke. So like it says, they need to put down exactly why those particular state laws ought to be applied in this case, or why they are not. So second, Juul seeks dismissal of the identified state consumer protection statutes in plaintiff's second and fourth causes of action for 1, failure to plead causation or reliance by not alleging exposure to misleading representations. 2, failure to plead reasonable reliance or a likelihood of deception. Juul argues that plaintiffs have not identified a particular misrepresentation, or that Juul's representations would not deceive reasonable consumers. It says, with regards to Juul's product labeling, Juul is incorrect on both counts, and its motion is denied. Plaintiffs have sufficiently alleged that at least plaintiff Colgate relied on Juul's representation that the pods contained a formulation of 5% nicotine, when plaintiffs have sufficiently alleged that the pods contain a formulation of 6.2% nicotine. I find that Colgate's reliance on Juul's representation of the amount of nicotine in each pod to be approximately equivalent to the amount of nicotine in a pack of cigarettes was reasonable. So this is mainly to do with misrepresentation. It's more to do with deceiving the public. And the Federal Trade Commission can certainly kick into place on this kind of stuff if they so choose to do so, for deceiving the public. Of course, this still has to be proven in a court of law, either before the judge or jury, probably before a judge. But this is one of the claims can go forward, because Juul is saying it's 5% nicotine when really it's 6.2% nicotine, which is over 60 milligrams of nicotine. I mean, either way, you're going to get addicted to this crap. But, you know, they need to put that, they have to advertise that. It's part of advertising. And they have not advertising on the e-liquid label. It has nothing to do with the label. It has to do with their advertisements on their website or wherever they choose to advertise that. It has nothing at all to do with the labeling. In other words, they don't have to put down it's a 6.2 or it's a 5% or whatever the hell else have you on the labels, on the e-liquid label, on the pod labeling. They don't have to do it. They can if they want, but they don't have to. But in their advertising, they have to. They can't misrepresent. They can't say it's 5% when it's really 6.2%. It goes on to say, Juul's motion to dismiss plaintiffs' identified consumer protection statutes in plaintiffs' second and fourth causes of action based on Juul's product labeling is denied. See, and this is mainly to do with like consumer protection statutes. It's also can come under federal law as well, federal statute, but mainly it's under state law, California state law. And like he says up here, he says the, see here, plaintiffs have only identified California's Consumer Legal Remedies Act with specificity. I can't do that. Anyway, the point is they they applied this, and they were very specific in how they applied it, and therefore the judge agrees that that particular claim or cause of action can go forward. And Juul's motion to dismiss that particular claim or cause of action is denied. This is the only thing here, this 5% as opposed to 6.2% nicotine, is really the only thing that the plaintiffs have going for them. Everything else is pretty much went in Juul's favor. And it says, as applied to Juul's advertisements, plaintiffs have not specifically identified what advertisements they saw and what statements in the advertisements were allegedly false, misleading, or unfair. This lack of specificity is insufficient to state a claim under the identified state consumer protection statutes. Juul's motion to dismiss plaintiffs' identified consumer protection statutes in plaintiffs' second and fourth causes of action based on Juul's advertisements is granted with leave to amend. So even though they dismissed it, nevertheless, it certainly can be amended. Because it doesn't, like I said, Juul doesn't have to put down on an e-liquid label, they don't necessarily have to put down it's a 5% or 6.2%. But in their advertisements, they do according to the state consumer protection statutes, which is the one they're relying the one the judge is relying on, the court's relying on, is the California State Consumer Protection Statute. But Juul can go and they have a leave to amend, and therefore they can certainly they could certainly amend it, as well as the plaintiffs can certainly, they have the leave to amend that particular claim as well. Juul argues that plaintiffs' claim for unjust enrichment fails because plaintiffs cannot allege any wrongdoing on Juul's part such that Juul's retention of any benefit would be considered unjust. It contends that because plaintiffs' other claims fail, the unjust enrichment claim would be duplicative and must necessarily fail. As I have found that several plaintiffs' claims survive Juul's motion to dismiss, plaintiffs' unjust enrichment claim is not duplicative. Juul's motion to dismiss plaintiffs' fifth cause of action for unjust enrichment is denied. So that's also, I apparently overlooked that one. Sorry about that. But that's also denied as well, unjust enrichment, because it's wrapped up in another claim, and therefore it's not necessarily duplicative. Yes. Let me look that up real quick. Even I don't know everything, but I don't want to steer you guys wrong in any way either, as opposed to some other channels I know. So what that mainly means is that unjust enrichment means that will Juul, forgot it already. Oh, this is terrible. Let me show you what it is. So I never even heard this term before. But anyway, unjust enrichment. In contract law, unjust enrichment occurs when one person is enriched at the expense of another in circumstances that the law sees as unjust. But they mainly fall under liability. So liability for an unjust or unjustified enrichment arises irrespective of wrongdoing on the part of the recipient. Rises irrespective of wrongdoing on the part. Oh, I see what they're saying. Okay, very good. Okay, so like he says in the duplicative, in other words, considering if the plaintiff won on one claim, and even though it's duplicative in a way that it's almost the same as the other claim, doesn't mean that it enriches the plaintiff like 2 against 1. It's hard to explain. I understand the theory of it, and it's hard to explain, but it doesn't mean that it like one claim turns into automatically 2 claims in and of itself against the defendant or against Juul. what he's saying is that it's not duplicative, that they're separate claims, and therefore there was no unjust enrichment. Hopefully I explained that. Yeah, I understand it. It's hard to explain. I never saw that term before. That's a new term for me. Very interesting. Unjust enrichment. Very cool. See, I'm always open to learning new things myself. Never saw that term before in any law that I've read. And I read a lot of law. I mean, a lot of law. I mean, I understand 99% of what they're saying here, except that one term. Anyway, so failure stated for design defect. Now, this stuff here is going to be bounced out. So it says, Juul argues that since the pods contains nicotine, a known addictive substance, there cannot possibly be a product defect any more than vodka is defective because it contains alcohol. While this may be true in a general sense, the alleged design defect is not that Juul's products contain nicotine, it is that they contain more nicotine than users expect. Juul's motion to dismiss plaintiff's design defect claim is denied. So another one that Juul lost on was, once again, it goes to that 5% as opposed to 6.2%. They need to correct that because they're deceiving the public. And then the manufacturing, once again, it goes to that 5% thing. It is too early to dismiss this theory. Plaintiffs allege a defect that could be attributed to either a design or manufacturing defect. As a result, they have pleaded facts sufficient to state a claim for manufacturing defect. Accordingly, I deny Juul's motion to dismiss plaintiff's manufacturing defect claim. Goes once again goes to that 5%. Says like it says. Let me read this so you understand it. Juul argues that plaintiffs have failed to state a claim for manufacturing defect because they have not alleged any variations among Juul's ends or pods. Plaintiffs allege that Juul routinely added more nicotine, salt, and benzoic acid to their pods than represented. While plaintiffs may not have alleged that a particular pod differs from identical ones from Juul, plaintiffs have plausibly alleged that these pods differ from the product that Juul intended to sell, that is, pods with 5% nicotine. This could be due to a defect in manufacturing rather than a design product. So it could be that maybe by accident, for some strange reason, Juul put 6.2% rather than 5%. Who knows? And like he says, it is too early to dismiss this theory because the court doesn't know exactly if it was intentionally put in there by Juul or it was just by some kind of manufacturing defect. Who knows? Maybe it was just one particular pod that had 6.2 instead of 5%. Maybe all the other pods have the 5%, but not the 6.2%. Who knows? So the judge, for right now, is denying Juul's motion to dismiss plaintiff's manufacturing defect claim. Once again, see, it goes all to this thing here, man. So it goes on to say, Juul argues that its alleged misrepresentation of the percentage of nicotine contained in its pods does not render their products unmerchantable for failure to conform to the promises or affirmations made on their containers because plaintiffs have misread the 895 patent and Panko study. At the motion to dismiss stage, I must accept all the factual allegations as true and draw all reasonable inferences in favor of the plaintiffs. For the purposes of this motion, I accept plaintiffs' factual allegation that Juul's pods contain 6.2% nicotine rather than 5% Juul represents on the packaging. I find that plaintiffs have successfully stated a claim for implied warranty of merchantability based on the allegation that the percentage of nicotine in Juul's pods does not match the represented amount of nicotine on Juul's containers. Juul's motion to dismiss plaintiff's implied warranty and merchantability claim is denied. Now, once again, this particular thing has nothing to do with the Family Smoking Prevention Tobacco Control. It has nothing to do with the FDA. This has to do with state implied warranty statutes. In this particular case, California. And so as far as California, let's say, for instance, you buy a package of pancake mix, but really it's waffle mix in there. And you go spend your, couple bucks or whatever it costs for the pancake mix. You take it home, you mix it up, you put the milk and the egg and whatever else, or the water or whatever in there, you mix it all up. You cook it and you serve it, and your family's like, we were expecting pancakes, not waffles. And that's a perfect example. So it's the same thing as this. You can't put down on your labeling, let alone the advertisements. The advertisement is a separate claim, by the way. But you can't put down on your labeling or on your containers that it's one thing when it's really something else. And so under those state laws, California state law, that particular claim is denied. And once again, it goes to that 6.2 as opposed to 5%. Now, this is going to be hammered out in court. And this is, like I said, October 30th, 2018 ruling. So I'm sure since then they've been hammering this out in court. And I'll keep you guys up to date what's going on here. Breach of warranty. Says Juul's motion to dismiss plaintiff's breach of express warranty claim is granted. Plaintiff's breach of express warranty claim is dismissed with leave to amend. So they can amend it. It's not with prejudice. So they can amend it. And basically what they're talking about is this. Juul argues that plaintiffs cannot state a claim for breach of express warranty based on advertising and other descriptions of the product rather than breach of a written contractual warranty without alleging the exact terms of the warranty. It also contends that the provisions of its express limited warranty necessarily bar plaintiff's breach of warranty claim as it only provides a limited one-year warranty. Now, I don't know how long they had their products. Maybe it was less than a year or more than a year. The key is that they can amend it. So the plaintiffs will go in there with the lawyers and amend it, and hopefully it'll satisfy the court. If not, then that will remain granted. And then negligent misrepresentation. This is a big one. This is a biggie. They can make a lot of money on this. The plaintiffs, because this is all it's about is money, by the way. Negligent misrepresentation. I mean, that's a biggie. Plaintiffs, if they win on this stuff, they can make a slew crap load of money. Yeah, let's see. And once again, it's going to this 5% as opposed to the 6.2%. Because they're misrepresenting exactly what's in their pods. Now, hopefully, Juul, for their own sake, they can prove to the court when they amend their particular motions or amend their particular claims, that is the motion to dismiss, and they amend that, they can prove to the court, by the way, it's not 6.2%, it's 5%. If they can win on that, probably this entire case will go into Juul's favor. But everything is hinged on that 5% as opposed to 6.2%. So it says, because Colgate has sufficiently pleaded reliance on Juul's representation on the amount of nicotine in the pods, Juul's motion to dismiss plaintiff's negligent misrepresentation claim is denied. Now, negligence is huge money. That's where the money's at. All the other claims or causes of action, yeah, a lot of money too. But negligence is huge money. And Juul better go in there and prove to the court that it's really 5%, not 6.2%. And it's not isolated cases. And then dismissal of minor plaintiff's claims, argument raised in the reply. So this is the reply to the motion to dismiss. Juul asked that I dismiss the minor plaintiff's claims in its reply brief. Actually, it's a reply to the complaint. So it is improper to raise a new argument in a reply brief. I will not consider Juul's motion to dismiss the minor plaintiff's claims at this time. The minor plaintiff's claims is the person that's under the age of 18 that goes by MH, because they have to protect the person under the age of 18. So anyway, so you can't raise a new argument. Like I said, it is improper to raise a new argument in a reply brief. So that's the end of that. So the motion, so it says Juul moves to strike plaintiff's nationwide class allegations pursuant to. Juul argues that a nationwide class would be inappropriate because material variations among the laws of the many states would require detailed inquiries into the legal elements, recognized defenses, and remedies applicable under each state's laws, overwhelming common issues, and precluding predominance. This motion is premature. So, in other words, the court's not going to rule on this yet. Not just going to dismiss the entire thing out of the blue, the whole entire class action suit. Like it says, for one thing, the pleadings are not settled, and plaintiffs indicated at oral argument that they will amend with sufficient specificity to allow all of their claims to proceed. So they're going to amend it, and hopefully it'll go forward for the plaintiffs. If not, then whatever. While class allegations may be stricken at the pleading stage in the appropriate case, doing so is not warranted here, as defendant, that is Juul, has not presented any argument that would completely preclude class certification. Juul's motion to strike plaintiff's nationwide class allegations is denied. So the conclusion is, for the reasons outlined above, Juul's motion to dismiss is granted in part and denied in part. And I don't have to go through it all because I just went through it. It says, to the extent that plaintiffs' remaining claims are based on mislabeled nicotine percentage on the packaging for Juul's pods, Juul's motion to dismiss is granted only as to the breach of express warranty claim and the unidentified state law consumer protection statutes claim. These claims are dismissed with leave to amend. So they're going to go back in there, the plaintiffs, to amend it, to make it better, to correct it. Juul's motion to strike plaintiffs' nationwide class allegations is denied, as it is not ripe at this stage of the litigation, because there's many other things that are going on that need to be answered and presented to the court before the court can say, well, by the way, the entire case is dismissed. That is against Juul, and it is so ordered. I love this word, ordered. That's how I've been saying, you guys could talk about me all you like, about my past, all this other shit, all you like on YouTube, offline, online, it doesn't matter. All that matters is a court of law. Why? Because it's ordered. And in a court of law, they could do three things to you in the United States of America. They can kill you through the death penalty. They could deprive you of your liberty, and they could deprive you of your happiness. In this particular case with Juul, they're going to the plaintiffs are attempting to deprive Juul of their happiness or their personality. That's PERSONALTY. One of these are the three rights that every American has. And that is Juul's. They love money. They love money. They love things. They love to buy things to make Kevin Burns, the CEO, happy. But the court could very well take those things away from Kevin Burns through a damages award. It could be $1 million, it could be $100 million, it could be $1 billion. I don't know if it'd be $1 billion, but it could be a lot of money. It could be in the tens of millions of dollars. And that's less yachts, less houses, less Juul pods made, less, outreaching to all the other countries around the world, the globe, to not only advertise, but to sell your pod systems. In other words, it cuts down on his finances, is what this court could very well do to him. It takes away from his pursuit of happiness. It's not going to restrict his liberty, but it's going to definitely cut down on some of his bank account numbers. Anyway, and that is the power of a court. That's a difference between the executive branch as opposed to the congressional branch, and then you have the courts. The courts, man, they have so much power. I mean, United States President Donald John Trump, he can order through the Defense Department a hit on some knucklehead in the Middle East and kill their entire family, and just have to face, the press. Was it rightfully done or was it not? Stuff like that, right? I mean, he has the power through the Department of Defense to order hits, right? Assassinations, all kinds of crap that go around the world through the CIA and all those other characters, right? But that's one thing, but that's mainly on those that are not Americans. But as an American, United States President Donald John Trump, or any presidents for that matter, the chief commander cannot just say, that American over there in Alabama, let's take his ass out or take her ass out. He can't do that. Not against an American without going through due process, without going through a court of law. That's the difference. If you understand the country we live in. Only a court of law can kill you, can issue a death penalty in a death penalty case. And even on United States Supreme Court, they can either have it so the state carries out the execution or not. They have the power, especially on the United States Supreme Court, to either kill your ass or keep you alive on death row. That's the power of the court. That's why I always say, if anyone listens to me anyway, that the courts have the ultimate power, because they could take your life, your liberty, and your happiness away, whereas the executive branch and the congressional branch cannot do that without going through a due process of law. I mean, you still have to go through due process of law with courts, of course. That's the whole point. But ultimately, in the end, in the very tippity-toe end, the courts can take your life, liberty, and pursuit of happiness away, whereas the executive branch and congressional branch cannot do that against an American without going to the courts first. Anyway, give me a little, why courts are so, they're the thing, man. Judges, man. To me, judges are gods. Lowercase g, even possibly uppercase G, it doesn't matter. They, to me, I don't know about to you guys, but a judge, even a jury for that matter, but a judge, because the judge will run that courtroom the way he or she needs it to be run, mainly by the rules of court. So even the jury has to follow the rules of court and the instructions of the judge when they have to go in there and make a verdict or whatever have you, pass a verdict. Ultimately, the judge is really the kingpin, so to speak, in a legal sense, that is. They are the guys and gals that pass judgment every single day of every single month of every single year in America. They could do it against or for an American. That's why I say ultimately it's the court system that really runs the show in the end. It really, really does. Even if a U.S. Supreme Court ruling came out and Congress goes in there and gets, I think it's a 3/4 or 2/3 to overturn the United States Supreme Court ruling, U.S. Supreme Court ruling can go back in there again and knock out Congress. And Congress is a very simple thing. Congress is the will of the people. That's all it is. That's all that Congress is all about. But the U.S. Supreme Court can overpowers the will of the people. Understand? Because our country is based upon laws. No one is above the law, not even the U.S. Supreme Court. So you understand these little things make sense as to why you are an American and why you are not an American. I'm a very proud American. I am. And you ought to be too. You have to understand the government that we live in and why we live where we're at. Why are we Americans? You have to understand the why of it to understand all the other stuff, as far as the what's and the hows and the who's and all this other stuff. You understand why, Anyway, enough of my talk. Anyway, so Juul Labs, they got some things in their favor and they got a lot of things against them. And a lot of that stuff that's against Juul Labs, the plaintiff's going to have to go in there and amend these particular causes of actions or claims and fight it out for some time. And eventually either it'll be completely dismissed, that is a class action suit, or the judge will hear the case probably, as opposed to having a jury, probably go before the judge, and maybe possibly even before it goes before the judge, Juul Labs Incorporated, Kevin Burns on down, will say, look, they'll get together with your 5 law firms they hired, and they'll say, well, if we can make a deal here, because there's a good probability I'm going to lose here, let's throw $50 million, $100 million, $200 million, whatever the hell it may be, to the plaintiffs and seal it, and no one knows about it, and it'll be a sealed document of the court, and la-di-da. Because Juul Labs eventually going to have to say to themselves, okay, so far we spent $40 million on law firms, and what's a $200 million deal, right? I mean, might as well give $200 million to the plaintiffs and stop this action at law, settle on it, get it approved by the judge, and call it a day. Because if not, these law firms are going to cost me over $100 million, and that's what Juul Labs will have to, finally, and they have to make that decision eventually. Is worth it to them? And it becomes, most of these settlements, not all of them, but majority of them are sealed, so no one knows about it, unless somebody, breaches that agreement. And then there's all kinds of penalties and goodies that come out of that. But anyway, so maybe, this is a big deal. And hopefully maybe, let's say Juul Labs, they settle. And then they say, well, let's correct the situation so we don't wind up with another class action suit. So here you have Juul Labs Incorporated going after all these counterfeit Juul products. And meanwhile, Juul Labs is in the hot seat as well. So there's always, for every 4 there is against, and for every against there is a 4. The yin-yang of reality, so to speak. I don't believe in yin and yang, but that's basically what it is. Anyway, I wanted to share this with you. I'll keep you guys up to date on the Juul Labs case. I will keep you up to date on the Nicopure Labs and Right to Be Smoke-Free Coalition against the FDA case. And the health groups, the Pediatrics, American Lung Association on down the line, against the Food and Drug Administration. They are the 3 main ones that I keep my eye on, I keep, focused on. Anyway, until the next one, you guys have a good one. Any of you guys that made it through this video, I salute you. I not only that, I respect you. that you have the intelligence level to get through these videos. They're very strenuous. They're very strenuous, and they're very difficult to get through. But the good thing about it is when you get through it, you actually learn something and you get deeper understanding of what's going on here. So when you go to all those other knucklehead channels, you could point things out to them and let them hopefully learn, if they even cared to learn. Probably not. Anyway, I'll let you guys go. Have a good day. Bye-bye.